Okay. So, friends, first of all, I would like to share that it's been 1 year since Immigration Forum was started, and we all know that it has been certainly an incredibly challenging yet fulfilling year and also fulfilling journey. We are thankful to the community who continue to support us and the lawmakers who graciously engaged with us. We are particularly thankful to the staff of Senator Mike Lee, the primary sponsor of S386, and also staff of Senator Durbin for patiently engaging with us in meeting after meeting. Most of us only heard from second-hand information so far. So I take this opportunity to say that I am proud of Immigration Forum team and supporters who placed their trust in us and as we engaged the conversation with Senator Durbin over many months. We started off explaining the situation to the community, of the community, asking for support, and eventually getting Senator Durbin's support for S386. Being able to do this for the community, it is very humbling. And many of us already know that this is not just support of one senator, but he's the top Democrat in the Immigration Committee and commands a huge amount of respect. Please be assured that we are continuing our efforts and we keep at it till the discrimination is removed. Thank you so much for that. Now I will move on to our attorney, our special guest, and our host, Ranjit, who have agreed to do the show. So first of all, Tiffany, thank you so much on behalf of the entire backlog community for your consistent and vocal support for S386, that is to remove per country cap within high-skilled immigration. We sincerely appreciate that. Now, elimination of country caps remain to be the primary goal of Immigration Forum, as we all have discussed. Could you please help us compare the advantages of passing S386 with the opportunity of adjustment of status that we have due to spillover? Thank you for that.
Yeah, so even if, everything was passed tomorrow, which that means that, the House of Representatives and the Senate, they come together and they pass what basically is what is currently in the bill. There's several months before it is actually enacted, and then there is that time frame in there for full implementation. And it is a path to the green card. So it's not automatically, it's basically the opportunity to file for adjustment of status or file for the permanent residence at the consulate without, there's probably still going to be a visa bulletin but it's going to be, everyone is going to be, there's not going to be rest of world. There's not going to be row. It's just going to be world. And there's just going to be one line for each preference group. And so that would still be there until there's no one in line, until it's always current, which we, maybe one day. So it is not going to be instantaneous. So for those that have the opportunity to go ahead and file for their adjustment of status next month, whether it's because their EB2 or EB3 are actually on that filing date chart, or by downgrading to EB3, they can take advantage of filing next month. It's a fantastic time to do it and kind of get in line. They're already in line, but get into that full queue so that there's can be employment authorization. So eventually portability can kick in, so they're not always dependent on H-1B and renewals and the timeframes not being, H-4 EAD, when that expires, there's no kind of grace period. Whereas an EAD that's based on adjustment of status has that extra 180 days in there. So there are a lot of benefits, even if the wait time in adjustment of status is long, which I hope it isn't, but even if it's long, it's still better than not filing. And I don't want to put too, because there's some people that are like, oh, well, maybe in November I might have a chance to file. And don't want to, stress people out by not being able to file in October if they're not, but it is a great opportunity, and it basically kind of bides your time until permanent visa equity is enacted. So, like I said, even if the 386 is passed tomorrow, people will still want to file their adjustments if they could. And even if it was downgraded, because again, there's going to be movement in the future, but at least they have kind of a jump on it.
Thank you for that. Now, just on the follow-up on the same topic, this is to say that even if S386 were to be passed today, we would still apply for adjustment of status as soon as possible, because the latest agreed of S386 has an enactment date of October 2023, which is 3 years from now, if even signed any day after tomorrow. Is that right understanding?
Okay, so there's, like I said, there's going to be there's the kind of enactment period, and then there's the full implementation period, which again is down the road. And the reason why they did that is that was the compromise, so that's essentially the hold harmless provision to allow rest of the world to be able to kind of clear up that queue before kind of there's no cap, no per country cap. So like I said, it is going to be, 2 years down the road, essentially, before really there's everyone gets to enjoy the benefit of the legislation. And that's why maybe if there's changes to it and that is narrowed and shortened. But yes, as to answer your specific question, there is going to be that long period of time. So you can take an opportunity of what you have now. So because obviously it's not going to pass tomorrow. So I know the hypothetical, I want to follow the hypothetical, but I also am very pragmatic and very practical, and it's probably not going to be the case. So so.
Sure, thank you for that clarification. And one last question before I hand over to Ranjit.
Okay.
So with this current opportunity, even though it is providing relief for only portion of people, our advocacy to S386 must continue in full rigor. And we would get your agreement on that, right?
Oh yeah, because this is, this has happened before, right? So I remember July 2007, everyone got to file, and March of 2012, a whole bunch of people got to file. And so, that was what, 8 years ago or 7.5 years ago, and the other one was 5 years before then. We can't just keep on waiting for these little Halley Comet of filing periods, because that's not sustainable. Because every day that equity is not implemented, is the queue just gets longer. And so you can't let up on the gas. Okay, keep the foot on the gas, keep it in drive, kick it up maybe. I don't drive stick shift, so I don't know what that means, but you kick it up to 6th gear, I guess. But just don't let off. Until it is signed by whoever is president, and they put their initials on or signature on there, then you got to keep on going, because these little fixes, while fantastic and we welcome them, it's not sustainable.
All right. Thank you so much for that clarification. And I hope all the viewers that are enjoying this show would actually take that in mind and continuously participate in advocacy. Thank you so much. Over to the wonderful host, Ranjit.
Good evening, everyone. Welcome to the live show brought to you by Immigration Forum. My name is Ranjit. We are here today with the prominent attorney, Tiffany Baldwin, to discuss the latest updates on Visa Bulletin, frequently asked questions on the adjustment of status, and all other immigration matters. You can call the numbers displayed on the Facebook page and ask any question. We will start taking calls in about 20 to 30 minutes. We'll discuss before that. Hi, Tiffany. How are you doing?
Good. How are you?
I'm doing great. Thanks. I know you have been vocal about the country cap, discrimination and everything. We really appreciate what you've been doing and advocating for equality. Before starting the show, I would just like to repeat the disclaimer here. Please note this show does not provide any legal advice. It is general in nature and it is only for informational purposes. We are not responsible in any way for your actions. Use this information at your own risk. If you need a private consultation with the attorney, you can always reach Tiffany by booking an appointment or scheduling an appointment, not just emailing. You may not get any response because I know everyone is swamped with emails. It has been a crazy week with, it has been a roller coaster ride. So before that, I would just want you to give a brief introduction about you before jumping into questions. Could you please introduce yourself to the community?
Sure. My name is Tiffany Baldwin, and I've been practicing immigration law since 1997. I actually was a law clerk even before that, but licensed attorney since 1997. I was initially with another firm with a very long time immigration attorney who has since retired. And then I went out on my own for a little bit when my children were really, really young, and then went to a big firm. And at some point I was the only immigration attorney there and really the only one generating immigration work. And I thought, sometimes people in the large firms, they see immigration law as not as business worthy. So I figured if I want to have a seat at the table, I better own the table and the chairs that are around it. So I started my own firm about 6 years ago. It'll be 6 years, December 1st. And it's been great. Now my focus has been on, although I do a little bit of family and naturalization every now and again, my focus has been on employment-based immigration law. And within that, even focus more on physicians, but also engineers, IT professionals. But docs are my daily dose of immigration, so to speak. I also am a daughter of an immigrant. My mother was born in Iran and met my father when he was stationed there at the embassy. And so I actually have her green card in my office. It's very special. And I'm also a daughter-in-law of an immigrant, as my husband's mother is from Italy. So immigration is kind of in my blood, literally, and it's been my career for more than 2 decades. And then I've been fortunate enough to grow my office, and so I have a young associate and a paralegal who used to be Claire McCaskill's constituent services person for immigration, and so, we're just ready to get these adjustments done. But I've really enjoyed doing immigration work, not as much under this administration, but it is, I feel sorry for my friends, my colleagues who do like real estate or stuff like that, because there's not a lot of that people contact. And I really love my clients because it's a great diversity and vibrancy. And I appreciate that this is how this country is built and is sustained. So I feel a part of it every day doing what I do.
Thanks, Tiffany. Thanks a lot. I know it's not just immigration. It's always, you have to have empathy towards the clients and empathy towards all the people, the beneficiaries, because it's not just any other profession. It's, you have a responsibility on your shoulders. And I believe, all the frontline workers and doctors are very thankful to whatever you have been doing and, helping them a lot. Let's just start with different questions rather than, the common ones. First, let's start with the good news. USCIS fee increase has been stopped by court. Yes, at least that good news for a lot of employers and again employees if they have to bear it. So could you please throw some light on it?
Right. So, when there was a fee increase in 2016, and that was supposed to sustain us for quite some time, and they weren't huge increases. It was really reflective of the increased amount of work, cost of living goes up. So obviously the immigration workers have to be paid more. So it was kind of in line with your normal increase. This came out of the blue. And it was almost like a money grab. It was very cynical, kind of keep people from filing for naturalization. I mean, there were some, you could see where there were huge increases in what this administration did not want, the type of immigration they didn't really want. Surprisingly, the I-140 actually was a decrease in cost, but nonetheless, there was just so many increases, and not just the cost. For instance, in this example, what we're dealing with now is that, since 2007, since August of 2007, so what is that, 13 years? There's been one fee for the adjustment of status, the EAD, advanced parole, and all the renewals each year or every other year, the renewals. And this was going to be, that's going to be, it was like a $1,200 annual cost almost for EAD and advanced parole. And so not having that was probably the biggest relief in our office. Outside of this whole adjustment of status process, it also, the regulation also put forward the changes in the forms. And even as of yesterday, they had not published the forms. The H-1B forms we were waiting to do in our office, we couldn't do because everything was in draft form. So we're very relieved that now we can go ahead and get our work done. And so it's great. Now it's kind of to be enjoined. That means it's just kind of a temporary stop until the end of the court case. But as a practical matter, I think it's going to drag out enough where, and I'm knocking on wood as I say that, we're not going to see them. I mean, eventually we'll see increases, but it's going to be like the normal increase based on the additional costs in processing cases. So it was happy news.
Yes. Also, I think it's a big relief for the people who apply asylum and all, where they are helpless and they could not pay a lot of money, which if increase would have happened, that would have been a great burden for them.
Right, and that's where I think they really targeted areas where they did not want to see immigration, such as, or new citizens. It made asylum and cost prohibitive of all groups that should have, the cheapest, easiest way to process would be asylees and refugees. So yes, it's a welcome relief. And it is that group and those advocates for those impacted folks that really caused this fee increase. So a huge debt to those advocates, because if it wasn't for them, we'd be, paying additional fees come Friday. So that's why every voice counts, and we need to support the various different groups, because even if it looks like it's all for asylees or all for Indian nationals, there's spillover, and other groups benefit by progress in certain areas.
Any chance this could, again, USCIS could come back with any increase, or this is just going to be the final decision by the court?
Well, one of the reasons for enjoining it is that it was put forth by Chad Wolf. He is the interim acting head of DHS, and one of the reasons the court made for discontinuing or enjoining the implementation of this fee increase is that he shouldn't be in that position. He's unlawfully in that position. Those interim, those acting positions are only to be for a short period of time. Not unsurprising is that his nomination was actually finally put forward. And we know the makeup of this Senate and who controls this Senate. So if they were to approve his nomination and confirm him, then there's a chance that he would reinstitute the fees. But if he reinstituted the fees, there would have to, I would imagine, and administrative law is not my forte, but there would be another implementation period, because this was passed in August. You know, there are 60 days. So even if they confirm him next week and he passes it again, then we're looking at December. Again, I think that timing is not necessarily going to work. And so if I had to put money on it, it would be that we're not going to see those fee increases, because we're very, very close to the end of this current administration, and hopefully it's this, you know, it's the end. But we'll kind of have to wait and see. We'll probably know more whether or not we're going to see a fee increase, you know, by mid-November, when the results of the election and all come to the end.
Hopefully, you know, there is no fee increase. The second thing I wanted to talk to you about, it's good and bad news. The stopgap bill, I believe, just passed today, the Senate, which has a provision of increasing premium process fee. And also, as well, good news is that it's allowing premium process for certain applications like, you know, EADs, H4s, and, you know, a lot of other filings. We would just like to know your take on that, and when would it take effect? I know USCIS has to still decide and come up with the fee structure and all. So can you just throw some light on that?
Right. So typically, if something is passed, then there's usually kind of an implementation period. You know, for instance, the fee increase, that was a 60-day. So I'm not quite sure what that period is going to be, but yes, it is. There are good things in that. Be able to premium process EADs is fantastic. But yes, knowing that maybe premium processing might cost $2,500 or more on certain cases, when, you know, sometimes I cynically think of premium processing as a kind of like their little slush fund, because how else can they get money unless they like force you, you know, they delay on processing cases so long, people feel forced to upgrade to premium process. When if they would just process cases in a reasonable time frame, you would never have to file premium processing. So the fact that they can decide to raise them at more or less at will is concerning. But I think a lot of these things are not going to be immediate. Like, we're not going to see, at least in the next month, we're not going to see that kind of huge increase. Again, they'll probably have to update the form that has, you know, a certain time frame involved. So there's always going to be a heads up on when that date is. It's not going to be like it's passed and the next day it goes up. We're always going to have this kind of heads up, and it's usually a 60-day period, sometimes a 90-day period. So
hopefully it happens sometime soon, at least that, so people who are applying the I-485 and the adjustment of status now could utilize that premium process in EAD, and, you know, doesn't have the hassle of extending the H1s all the time.
Right.
Yeah. The other topic I would like to ask is about the I-944, the public charge form. There are a lot of news going around about it. You know, if you are submitting before October 12th, you don't have to submit it, and if it's after October 12th, you have to submit it. Is it the case that, or, you know, even if you submit before 12th, USCIS can come back and ask for it?
Well, yes. I mean, so what they said was, you're not required to file it prior to October 12th, but it's still a requirement. So just like kind of, it's treated almost like the medicals, whereas, yeah, you don't have to file with it if you're filing before the 12th, but eventually they're going to want to see it, and they're going to want to see the backup documentation for that. So, and the form is long, and it's, you know, it's a ridiculous form, but it's not the end of the world if you don't make it in before the 12th, as long as you, and then I'm telling clients that there's a huge long laundry list of things they want. But a lot of that stuff is kind of what I call RFE-able. I mean, they'll come back and ask for it, some mortgage statements or whatnot. So I think if there's bare bones documentation like tax returns or a tax transcript showing you continuously make money year after year, and bank accounts showing that you have some cash assets, that you're not just, as soon as the money comes in, the money goes out. That's kind of what they're not keen on. Then that's probably going to get your case. That's probably fine for getting cases receipted in. And that's what, there was a period where you did have to file with the I-944 up until the end of July. And that's what we found was that, if you submitted pay documents and asset, like cash asset documents, so bank statements, that was fine. And then we were expecting, a request for evidence later on that they would ask for the other things that they feel are missing, because they might not ask for some people who have a high salary. They may not ask for a lot of those little things. They may be satisfied by what you submit, and there is a provision, and it's a little confusing, and I don't want to get kind of in the weeds on it, but it's kind of like the affidavit of support that is used on family-based cases, is that you really don't need one if that beneficiary has 40 quarters of employment. So 10 years of employment, and you have, tax transcripts can show that, showing that you have such a sustained employment in the United States that you're good. So it may be the case, especially for those folks that have the 2010 and the 2011 priority dates. We know that they've been working here for 10 years. And so maybe with a tax transcript showing 10 years of employment, when they do submit an RFE or they send out an RFE, they may not ask for mortgage statements, stock information, 401k information. They may be good with that salary. So I think a bare bones kind of support showing assets and income is sufficient.
Sounds good. So we still don't understand, a lot of people don't understand that public benefits, most of the non-immigrants are not even eligible, like, right, especially the H1L1, and we still have to do a lot of documentation. That's kind of frustrating. We still don't understand what's the purpose of it.
Yeah, and that's a great question, because it's the purpose of it, like a lot of things that have happened in the last several years, is a very cynical view of immigrants and immigration. So it was instituted on the false presumption that foreign nationals applying for their green cards take more than they provide, and which is obviously, especially in employment-based cases, not true. If they're based on employment, they're earning money here. So yes, obviously, unless there's certain reasons, like pregnant women can sometimes get Medicaid, but that's really for non-immigrants, that's really it. There's usually requirements for Social Security. A lot of H4s don't have Social Security, so numbers. So that's why there's like a lot of no's, a lot of not applicable on that form, because for 99% of the folks filing for adjustment of status, it isn't going to apply. And that's why I think that form is going to be short-lived, and we won't see that in a new administration. That'll just be like, never mind. Yeah. Again, knock on wood.
Yeah. The other question, it's a burning question a lot of people have, especially where kids are aging out. I-485 filed under current filing dates will not freeze the child's age under the CSPA if kids are aging out. I know there is a lawsuit by Brent Renison that's going on, but then what do you think about, people who are aging out, and can you give a clarity if they are protected or not?
Yeah, so you're absolutely right. So if your priority date meets the filing date chart if your priority meets the filing date chart, but it doesn't meet the final action date chart, then the age isn't told. So it just keeps on, the kids keep on aging. They age for immigration purpose, just like for life purposes. And what Brent's done some great lawsuits, litigation over the years about, if your I-130 beneficiary passes away, to have the ability to do a substitute petitioner. That was Brent. That was Brent's doing. So I'm really glad that he's kind of taken the lead on this to protect the kids. There's obviously a huge issue with our H4 dreamers. And so, everyone in the media and people out on the street, you ask what a dreamer is, they'll say, it's the undocumented teenager or college student. But if they're going to get protections, obviously we want the H4s and the L2s and all the non-immigrant kids to have that protection as well. So I guess to go back to the answer to your question is that for the bulk of the folks that are going to be filing, they're filing because they're downgrading and because of the EB3 filing date chart. Yes, so their kids are still going to accumulate time. And that's why it's important for them to maintain non-immigrant status. So if, the primary comes out of, it's no longer an H-1B because they're just working straight EAD, that might be okay if that child goes on F1 for college, for instance. So as long as that non-immigrant status remains, they're somewhat protected because at least they have a solid non-immigrant status and not just status as an applicant for permanent resident, which is, does provide benefits certainly, but not to the extent that actual non-immigrant visa status does.
Sounds good. So at least let's hope, this court ruling comes sooner, and that way most of them are protected. That's what let's hope for. The other question, a lot of people have here is about what happens, a lot of people have questions about downgrades and all, now it has become a trend now, to be frank. So is there any memo on EB2 to EB3 downgrade, or, is, USCIS able to do the downgrade by law?
Yeah. So the only time that a downgrade, and this has happened, this is not the first time, this is not immigration or most immigration attorneys' first rodeo with regard to downgrades. So in 2013, EB3 China overtook EB2 China as far as quickness in the queue. And so there was a whole bunch of downgrades then for Chinese nationals. And so it's the same here. And essentially, and it's obviously a little bit easier than an upgrade would be, right? Because if you qualify for EB2 for that position, it seems like that would be the same for EB3. The only caveat to that, and it doesn't impact most of the people on this call or even most of the people out there, but physicians that have their I-140 in the EB2 category based on a physician national interest waiver, which is not based on PERM. It's based on service in an underserved area, but it says in the actual notation that it's based on it because you have to have an advanced degree, that medical degree. So they're not eligible for a downgrade, but if you have at EB2 based on a PERM filing, you can downgrade to EB3. Now, what if everyone and their brother files under they all downgrade to EB3 and EB2 shoots forward, right? We can all hope, right? In that case, there is a process to convert a pending adjustment of status back to EB2 using that same I-140. The key to a downgrade is that even though the EB3 I-140 is going to be based on that perm that was the basis for the EB2 I-140, it's not an amended petition. So there are different boxes on the I-140 about, whether, because it covers the EB1, EB2, EB3, special immigrants, the whole ball of wax. And then there's one box that says, is this to amend a previously approved I-140? And some people think, oh, well, it is kind of, right? We're changing the basis, but it isn't. So if it is treated as a brand new petition, then you have two I-140s based on the same perm. You have the original one, which is EB2, and then you have this new one that is EB3. If it's filed as an amendment, that EB2 I-140 essentially goes away. So that's a very important thing. And of course, the folks on the call that have representation, the attorneys should know that, hopefully. I know Ayla and other things that have been out there have kind of hammered home that point that this is not an amendment, this is a brand new petition. So if it's not an amendment and you have two perfectly eligible I-140s, they can be substituted. And the same is true for, I've had cases where, it's the 2007 or the 2012 windows. So they were able to file, their case has been pending for a long time. In that time period, they went from being, an electrical engineer to all the way up to now they're an engineering manager or director of engineering. It's a whole other occupational code, right? So the employer might file a whole new perm, get a whole new I-140. That I-140 can be substituted for that pending application. So now, and I don't know if they've changed this, and this is my question, and I haven't had a chance because it's a crazy week and it's only Wednesday to see what the current guidance is. But in the past, immigration would only allow you to do that conversion once. So if you file the downgrade as an EB3, and a year from now, EB2 shoots forward, you do the conversion, but if it retrogresses, you can't go back to EB3. Okay. So you kind of get one shot to make that change while the case is pending. Now, they may have changed that, but that historically has been, you have one chance to make a substitution, essentially. Now, you could file a whole new adjustment of status if you needed to, and there was visa availability. But yeah, so there's that. So, but hopefully there's not a lot of back and forth in that time frame that adjustment of status is pending. Hopefully, it's EB3 to completion or EB3 and then go to finish off in EB2. So that should, like I said, probably 99.9% of the folks are going to fall either in that straight EB3 all the way through or convert back to EB2 at some point, and they're probably not going to need to do a lot of flip-flopping. But yeah, so that's available. So I'm trying to find a downside to downsizing. But it seems if there is even a little downside, I'm not sure if that is going to be more than the upside of simply getting on file.
Sure. It's more advantages than disadvantages. So
Exactly.
It's worth trying.
Yeah.
So another question here everyone has is, does it really matter if I-140 was withdrawn? Because now a lot of people want to go back to old employers. A lot of people might have already withdrawn the I-140. Does it really matter if I-140 is withdrawn? Can they just refile the I-140? Because there's a lot of people say that perm is valid even if I-140 is withdrawn when perm was filed on time?
Right. So, so it's all a matter of timing. So if the I-140 was, after it's been approved, withdrawn within, or if the employer files to revoke it or withdraw it in the first 6 months after it's been approved, then it's gone. It's gone for use for extension of H-1B past 6 years, and for maintenance of that priority date. Okay. And that's why most employers, and there's not a lot of reasons to withdraw an I-140 or revoke an I-140 once it's been approved. But some employers, especially smaller employers, or maybe even mid-sized employers, if they do a lot of perm filings and they do a lot of I-140s, there's the issue of ability to pay.
True.
And if immigration sees, Acme Engineering, and they have 24 I-140s approved, and they're now, immigration is questioning whether you have the ability to pay number 25. And they're, the company is smaller. They only have 50 employees. But 15 of those I-140s are people that have already gone. They're still held to being able to pay that wage. And so that's why you see employers withdraw applications, but typically they do that at least 6 months after it's been approved. So there's no negative impact to the leaving employee. They still get to file H-1B, for 3-year periods. They get to use that priority date for new filings. They keep their place in line, so to speak. If they were to withdraw before that time, that's just spiteful. And there are employers out there that are like that. But for the most part, if people have to withdraw, that's why. And they'll do it, they hold off and do it when they have to, not anytime before that, because it's not required. Unlike an H-1B where you have to inform immigration the employment is terminated, and you don't ever have to withdraw an I-140 even if the person leaves. So it's going to, whether or not you can use that priority date, it's going to depend on when that I-140 was withdrawn or revoked. Now, let's say, your perm and your I-140 was with employer A, and you're now with employer B, but employer B hasn't been able to get a perm on file for you. Maybe there were some layoffs, and so that delayed things because they couldn't, do the attestations, or because prevailing wages are taking so ridiculously long to get, whatever the reason. So, and I have a couple of these on my docket now. Sometimes it's a matter of the, and the employer, they would love to have that person back, if in the future, because perm and I-140 does not have to be for the position or the salary that the person is in now. That's why an employer can file a perm and an I-140 for someone that's not even working for them, that's in another country. You see a lot of nurses and medical technologists that come from, India and the Philippines or Korea, and they've never set foot in this country until they get approved for their green card. So it's for future employment. So if it is, they're like, oh, I have, some physicians, they had to leave and move to another employer because their first employer lost a contract at a hospital, and so they just couldn't work there anymore. And they're like, but we would love to have you back. And if they will, support the a new I-140 if you need to downgrade, or they'll support the supplement J, and they can legitimately say that yes, an offer of full-time employment is offered to Ravi, when the green card is approved, then you can use that old one, even if you may be working for another company. So, but not every employer is going to do that. That job may not be available, right? It just may not be available. And so there's that question, but when you file an I-45, if you're filing it just just alone, it needs to be based on an I-140 that there is still an offer of full-time employment for. If you're downgrading, the I-140 has to be filed by the company that did your first I-140. And so, or not necessarily the first company, but if you're downgrading from Acme Engineering EB2 and you're using that as the basis of your filing, that's the company that has to be on the I-140 downgrade petition. So I just threw a lot of information out there, but so, and I don't want to get that lawyer answer, oh, it depends, but there's so many different variables. And it depends on, who did the first, when was it withdrawn, all that go into play. And that's where sometimes it's hard to kind of give general information because some people have like really quirky employment history, and I've seen a lot of it in the last 6 days. Not everyone is they have a very, very straight path to the green card.
True. So it really doesn't matter if employer has withdrawn after 180 days and then still want you to be back and file an adjustment of status in a nutshell.
Yeah, I mean, if they've withdrawn, again, that priority date still holds, and the other benefits of that. But again, if you're using that as the basis of a new filing, that employment still needs to be available in the future.
Sounds good. Other people now, because of COVID, a lot of people got stuck in India or all other countries and they're unable to come in. Now the spouses are here and they are able to file an adjustment of status, but unfortunately they cannot include the dependents. So we know we cannot include, at what point of time can they include them again?
Right. So it's very important that if dependent family members are not filing at the same time, that means the non-immigrant status needs to be maintained. The H-1B needs to be maintained. Even if you have an AD, you're going to have to maintain H-1B because you can't have an H-4 without an H-1B. The H-1B goes away, the H-4 status goes away. And so the next opportunity to be able to file extension of status for H-4s that can file in October would be when that primary's priority date is available for filing. So if it gets fingers and toes crossed, I'm not very hopeful, but if it continues through November and some of those dependents are able to return to the United States, then they can file at that time. And sometimes it gets a little tricky if we're not talking about H-4s, we're talking about an F1, let's say a child who's coming back, or I'm trying to think, because when you enter, H-1Bs who enter, they can have an immigrant intent. They can have non-immigrant intent. They can have immigrant intent. Visitors, B1, B2 visitors, they have to have a non-immigrant intent. F1s and F2s have to intend to return home at the end of their stay and not, file for their green card. So if your child is stuck outside the country and they happen to be on F1, then it gets a little tricky because when they enter it, the next day they file for the adjustment of status, maybe there's a red flag that says, what was their intent when they came through CBP? So, but that's kind of probably those
very rare,
few and far between. Most likely you're going to have, H-4s or L-2s coming in, and there's not an intent question for them. And so they come in, you got to maintain that non-immigrant status. And then the next opportunity, I got a call today. It's like, I've been maintaining H-1B since 2012. And now we can file for my wife, because he married her, later on. So we were able to file because his priority date fits into that. And even though he already has a pending adjustment of status. Now she finally can have adjustment of status. So sometimes it's just a matter of, you gotta wait, which is, if there's any way possible to get them back, you can even do all the forms ahead of time and get them all ready. And as soon as they enter, you update that I-94 number and shoot it off. But I know that it's really, if they don't already have the visa stamps, getting the visa stamp at the consulate is next to impossible. And so, even if you can get a flight, again, there's that impediment.
One last question before we take questions from callers.
Yep.
Now a lot of people are filing a downgrade along with the adjustment of status, and a lot of people, if they want to switch an employer, they can switch after 180 days. But the question is, what happens when I-140, I-485 altogether are pending, and the change in employer, let's say after 6 months, I-140 is still pending? Can the next employer take it from there by just filing a supplement J, or no, because I-140 is pending there?
Right. So this is where, and I wanted to, because I know in past talks, I was like, well, technically in the regulation, once an adjustment status has been pending for 180 days, you're a free agent, you can go. There are some risks if the I-140, so if we're talking about downgrades, because if we're talking about someone that just can file the adjustment of status because they already qualify with their current I-140, 180 days, they're good to go. But for the downgrades, there is that risk I mentioned, which we talked about, withdrawal and revocation, right? So if the case is pending still at 180 days, if the I-140 is pending at 180 days, there's the risk that if you leave, even though you're allowed to port at that point, if you have an employment authorization card, that I-140 employer can withdraw that pending application. And then if there's not an underlying I-140 pending, then the I-45 can be denied. So that's a risk. And that's why it's really, unfortunately, we can't premium process the downgrades, or at least not initially. My way immigration says is that because you're not filing with an original perm approval, they won't do a premium process. And premium process cases go to Texas. A lot of the older I-140 petitions were filed in Lincoln. That's how they used to divvy them up, although you might find Texas in there as well. And so there's a risk in getting it. And I'm departing from your question, but I wanted to get this clarified. But there is, if you're filing in the same location as your original I-140, I would go ahead and file regular. That's the safest thing to do. Get it receipted in, and then maybe a month later, file to upgrade it. And that way it's already there. It's already been receipted in. They're not going to reject it. They might reject the premium processing, right? They might say, well, we still don't have the original, but they're not going to, there's not a risk that,
at least worth trying.
The wrong location. Yeah. So if you can get it premium processed, eventually upgraded to premium process, and it's approved, I would use that approval date as day one of that 180 day. And that's because if you do leave on day 181, you've now gone past the point at which a revocation of the I-140 negatively impacts you. And that might be, I'm a visual person, so I would probably like want to see a calendar to show that. But basically, instead of using your I-485 receipt date as your day one of your I-1 of your portability, is to use your new I-140 approval date as day one for your I-140, so that you can, if now hopefully people are not, especially if your employer happens to be paying for any of this, you wait a little bit longer than 180 days. Just employers really, really hate that. I hear, I'm like, why did you make me do this? They just left. But if situations happen, right? And it may not even be intentional. Day one, you may not be intending to leave in 6 months, but opportunities happen. You got to think, well, what's best for your family, whatever. But let's say you leave at, day 200, you're asking about portability, your new employer. If you're on an EAD, you can keep it on an EAD. You can also have them do an H-1B portability. There's questions about whether you go with what I call the belt and suspenders approach, right? And people will differ, and sometimes it changes depending on how long it looks like, or how clean your history has been. Sometimes things pop up and are surprising, but again, you want to be, I guess the short I'm very long-winded, but if I was going to be succinct, it would be that you don't want to port until after the period where a revocation of your I-140 would negatively impact you. So wait till you're all clear on that point. And then if you have an EAD, then go ahead and move to new employment. And eventually that new employer will have to file a supplement J. I mean, there's questions of whether you have to proactively file that. And again, it's in the gray.
Be safer than sorry.
There's nothing wrong with it. And I guess my concern is always, is it even going to make it into the file, or is it just going to go into some black hole at immigration if you file it? But I think if you do a nice cover page with colored paper and note that this is a supplement to the supplement J, that it would eventually get there. So there's no harm in filing a new supplement J, and that way your employment history continues, your non-immigrant history continues, your eligibility for adjustment of status based on employment continues throughout, and you don't have to worry about maybe getting an employment verification letter or documentation years down the road when maybe the HR person is gone and they're not going to be very helpful and whatnot. So I would submit supplement J's as you change positions, because it doesn't hurt. And even if it doesn't hit your file, if you maintain a copy as your attorney should and you should, then you have documentation that it was submitted.
Before proceeding, I would like to ask you, is that okay if we extend for another 15-20 minutes? Because I know we are past an hour. I just don't want to,
fine. I'm a night owl, so we're good.
Sounds good. That's really nice of you. As I said, again, you should be passionate again to do these kinds of things. And we really appreciate what you have been doing for the community. That really means a lot to us. Adding to that question, okay, let's say the I-140 along with the concurrent filing is pending. Will they get an EAD, or EAD is only processed after the I-140 is processed?
No. Once they go to immigration at the same, they're all in the same packet. They go there, and then they get divvied up. That's why you may need a G28 for the I-140, one for the I-485, one for the EAD. And then they get split up. You get a unique receipt notice for each one. And so they're processed, they're processed kind of independently. Sometimes the advanced parole, sometimes they'll come back with a request for evidence that's, about status or whatnot. But that's very, very rare. It's odd to get one. So they're, whatever the normal processing time is at the time you file, which is really varied lately. We got one back just today in 6 weeks, but we have others that have been pending for more than 4 months. So go figure. But yeah, so you can have you may have an EAD several months before you're eligible for portability. You just kind of hang on to that. Hang on to it, put it in your pocket, calendar the expiration date and when you can apply for an extension, and then bide your time.
Sounds good. Let's start taking the calls. The first call is going to be Baumik, the number ending 5264. Baumik, number ending 5264. Before taking the call, I would like to request everyone to not repeat the same questions. We have discussed a lot of topics. Please give an chance to other people who are in line and want to ask a genuine different question. So please, Baumik, go ahead. Your number 5264, ending 5264.
Yes, can you hear me?
Yes, go ahead, please.
Okay, quick question, right? I know we discussed a couple of things. Wanted to know if I have I-140 approved from previous employer and my priority date is current, but I have changed my job 6 months back. Can I file adjustment of status based on the previous employer's approved I-140? Since date of filing is allowed now till May 2011 for EB2 India.
So you only have the one I-140?
Yeah, I do have. It has been approved back in 2011 from my previous employer. I just changed the job 6 months back, and I'm yet to begin my PAN processing, etc., with my current employer.
Yeah.
What I want to know is there an option and provision now to file I-485 through my present employer based on the previous approved I-140, which is still valid, but from my past employer?
Yeah. So there isn't, because you have to have the offer of future. Well, this kind of goes back to what we were discussing before. But you have to have an offer of future employment in order based on that I-140 in order to file the adjustment. So, I mean, you could, if you, and I've been telling folks this a lot in the last week, is that if you're leaving, the last employer was amicable, there's no burnt bridges, there's no hard feelings, it was just, it is what it is, you may want to call them up and say, I have this opportunity, could there be an offer of future employment available to me in this perm position? Obviously not right now. It is a long shot. I will be perfectly honest with you, but my philosophy is no asking, no getting. If you don't, the worst thing that can happen is like, no, what are you talking about? There's no way that we would do that. But you'd be surprised. I got, a call. They're like, yeah, my 2010 employers, that they said that, yeah, they're sure they would support the new, the downgrade I-140 and the supplement J, because they would love to have me back. And so you never know. So it kind of depends on your situation, whether or not you feel comfortable going back and asking if it was, on good terms, if that job would be open to you. Not that you would go back now, but that they would support that. And then after 6 months, it doesn't really matter, frankly. But it is kind of a tough question to ask, an awkward question to ask. I give you that, but otherwise, you don't have the basis. Immigration is going to come back and say, well, where was the support from the original I-140? Now, if you were, super duper close on a perm approval, and you know that it was going to be approved in, maybe by the early November, you might be able to, and I don't want, you might be able to file if you could substitute that I-140 pretty quickly. But that's a lot of ifs. And I don't think you're there, and that would be very, very case specific. Yeah, I wish
It's worth trying.
Yeah, it's worth, like I said, it's worth asking, and you just never know.
Sure. The next caller is Prasad, number ending 9693, number ending 9693. You are on the air. Please go ahead.
Hey, my question is, if my spouse uses, my spouse is a dependent and I'm the primary applicant, we both have our own I-140s approved. So if in case if my spouse uses my EAD, does it mean that my EAD and transfer is also being used? And does that also mean that my spouse's I-140 now becomes void?
No. This is spouses that have it made with these filings. They are in the best position, better than the primary when it comes to employment and flexibility. Yeah, if your wife is very lucky. And I don't mean to be too flippant about it, but so you're each gonna file for your own EADs. She's not on your EAD. You'll each have your separate I-765 applications, separate I-131 applications, separate I-485 applications. Everyone gets their own receipt number. Everyone has their own A number. It's all separate. Now, hers is obviously dependent on your adjustment being pending. If your case isn't pending, her case can't be pending. But once her EAD is approved, she can do whatever she wants on it. And again, her I-140 is always available. So obviously if both spouses were eligible to file in October, there's the argument to be made that they should file as individuals, because it's easy to go on to, it might be easier to go on someone else's as a dependent, but it might be harder to like separately file if you need to. But that's probably not going to be impacting a lot of people out there. Usually there's one spouse that has probably several year head start on priority date than the other. So you want the one that's furthest along, and that's the primary, and that's where the employment matters, and the continuation within the occupation, and the portability rules, all of that applies to the primary. The dependent, once they have their EAD, they can be a W-2 employee, but that also allows them to be an independent contractor, freelance, open their own business, have an Etsy store, drive an Uber, whatever. I mean, it gives them a lot of flexibility. And this may not be you, but for those that have children, and I know it sounds funny, but I've applied for EADs for like 2 or 3 year olds because it's a way to get the Social Security number. So you really only have to do it once, get the card, get the Social Security number. And that's because sometimes that's the only way to get one. Or if they're getting close to driving age, an EAD is not a bad idea for a young, and to have that Social Security number for filing for like college applications. So the EAD is very, very multi-purpose, even if you don't actually use it for employment. The DMVs, they love the they love the EAD card. That's knowable to them. I think maybe because it looks like a driver's license, that it seems like that's they understand it a little bit more. So, but to really answer your question, nothing happens with her I-140 by filing the adjustment of status. If something happens and it behooves her to file based on her own I-140 and kind of she could probably do that if, if the visa numbers are available. But no, it's just, a lot of spouses, especially if they both work as H-1Bs, have to have I-140s because if you don't get that past 6-year time. It's a great question though.
The next caller, Karthik, number ending 5744, number ending 5744.
Hi, Tiffany. Thanks for taking this call.
Yep.
With my ex-employer, I have a priority date of 2013 November. That was approved 140 with EB2. With my current employer, my perm got approved in July this year. And they applied for 140 in EB2 in regular processing.
Yeah.
So when I spoke to my employer, he was saying we should be downgrading it. So are you recommend to file EB3 in parallel, and can we process that in premium?
So you mean you want to downgrade the current one? They might
It's
be
pending.
able,
It's pending. I mean, looks like the I-140 is pending now with the USCIS.
okay. I mean,
That's right.
you might be able to amend it to, and I don't mean like downgrade amendment. I mean, while it's pending, see if you can change the basis. Now, a lot of times once you file it, everything is kind of cooked in and you can't change it, but you may want to contact the ombudsman to see if they would permit while it's pending to amend from EB2 to EB3, and that way you don't have to file a new thing. Or if you upgrade to premium processing, and in that upgrade request that the I-140 be changed to EB3, again, they may not, because typically they don't like to make those changes or corrections, but it may be worth a try, because that way you'd already have an approved I-140 in EB3 using the old, and that way you have the old they're using the old priority date, because that's key too, because sometimes they mess up and they give you the priority date on your current perm. So when it's pending, you don't really know, because they don't put that on the receipt notice. Well, sometimes they do, but very rarely. It's kind of a mistake when they do, because it's not really cooked in. It's not really concreted into your immigration history until the I-140 is approved. So you might be able to amend through the premium process. Like, we want to upgrade this to premium process. And by the way, this meets the EB3. We would like to amend the I-140 petition and request the EB3 category. So, check with your employer, check with counsel and see if that's something, but you would really want to have that approval before you filed your adjustment of status. So premium processing is probably in the cards anyway. And then if they won't amend and they disapprove, then you have to turn around and file a whole new I-140 in the EB3 category, unfortunately. But that's why it's kind of like asking an old employer if they'll take you back. The worst immigration can do is say, no, we're not going to amend from EB2 to EB3 on this currently pending I-140. So it's kind of worth a shot.
Sounds good. The next caller, Kranti, number ending 6371, number ending 6371.
Hi, Ranjit, and hi, Tiffany. Thanks for taking time for us. So my question is, I am with a company for almost 10 years. I have an approved I-140 on EB2. My priority date is February 2012. So it was previously owned by a different owner who is now facing some criminal charges for some fraudulent visa issues. So do you think I can go ahead with downgrading to EB3 and file my I-140 if there is any risk of it getting rejected? And if it gets rejected, does it have any impact on my current EB2 I-140?
Yeah. So, no, I mean, if your I-140, it sounds like it's been approved for a while, given your priority date. It must have been approved probably, what, 7 or 8 years by now. And so
February 2012.
yeah, so that's quite some time. So the I-140, unless they can show fraud or misrepresentation at the time that first I-140 is filed, you're good to go with that. So if you're doing the downgrade, one of the key things, and it's unfortunate that there's, the fraud involved has to do with immigration, but they're going to want to see that there's that ability to pay. So not only that, I mean, it's helpful that if you're getting paid what that proffered wage was, and I'd imagine if that's, you were making way more than your 2012 wage, I would hope so. So that's kind of one issue. That obviously financials from the employer, so either the tax return or some other documents, depending on how many employees there are, would have to be filed. That's probably going to be the key. Is it like a sole owner, or is it just like one of the upper management that's facing these charges?
Oh, I think he's already off the line.
Okay.
Okay.
Yeah. So I mean, if it's almost like a sole proprietorship or like this single owner, and they're facing fraudulent immigration charges, then there's an issue there. I would say if you did move forward, you certainly want to, until the I-140 is approved, maintain that H-1B, because if it goes south, if they deny the I-140 and then deny the I-45, you still have your H-1B intact. And so that's key, just maintaining until you're kind of in a safe position with regard to the new I-140.
Sounds good. Okay, before I drop into the next question, one question I have here, can someone travel when 485 is pending and EAD is not received? Are there any complications? Are they allowed to travel?
So the regulation, because the H-1B does not have that forced non-immigrant intent, you can have dual intent. So H's and L's have a special provision that if you have a valid visa stamp in your passport, so you have a valid H-1B visa stamp in your passport, and you have the receipt notice for the I-45, you can travel on that. So otherwise, if you don't have a valid visa stamp in your passport, you have to wait until you have your advanced parole. Now, back when the local immigration offices were a little bit more robust in their provision of services, they would allow you to make an InfoPass appointment to get like an emergency advanced parole if there was like a death in the family and you had to travel before you had your advanced parole. That is incredibly difficult now, because it's hard to get into immigration because of COVID anyway. And then last year they kind of took away InfoPasses for most of the offices. And I don't think there are any offices that do InfoPass anymore. So really, you got to wait for that advanced parole to travel if you don't already have an H-1B or an H-4 visa stamp in your passport. If you have that and you have your receipt notice, you'll have to carry that with you. Then you can travel.
Okay, sounds good. So there are no restrictions. In other words, as long as you have other visa, you can just travel when 485 is pending.
Right, but you have to wait for that receipt notice, and there are. I mean, this is, if you're working, you're probably not going to be gone for more than 3 months. But generally, definitely not longer than 6 months. But really, I always tell, sometimes they take long trips. But you want to definitely keep any travel less than 3 months while your adjustment is pending. That's usually not a problem, because how much, people usually don't have that much vacation time, but that's just something to keep in mind, that they should be short trips out of the country. Even when you have an advanced parole, they should be short trips out of the country, because really that parole document is just intended to make, again, the whole purpose is so that you can make brief trips for business and personal reasons while your case is pending, not for you to like file here and then leave town for a long time.
Yeah, the whole point is again maintaining the permanent residency status, and obviously it's a privilege, it's not your right, so you have to not misuse it.
Yeah.
Yeah, the next caller, number ending 7797, Murthy, number ending 7797, you are on the air. Please go ahead.
Hi there, my name is Murthy. Thank you so much for your time. Really appreciate it. My question is, I'm with my current employer for nearly 10 years now. They did apply for my I-140 before with a priority date of Feb 2012. Unfortunately, there was a silly mistake done while filling the application, so it was rejected, for which we appealed, providing all the necessary information and underlining the mistake that was done and the supporting documentation why it was wrong and what's right. But we never heard back anything. So we did refile another application, but that pushed the priority date to 2015 April. I just want to check if anything I could do to reuse the previously filed priority date, which is 2012. Anything I can do to make sure that I get that priority date at the moment?
Yeah, so you would even have to have the approval of that 2012 I-140 or documentation that it is still somehow pending. So I'm sure you've checked the case number on the status line, but you can also, if it's not showing anything, it's not showing any status, you might be able to use the CIS Ombudsman inquiry system. Sometimes they can't do anything, but they certainly do make those inquiries and help kind of resolve tricky cases. It may be so long ago that stuff may be archived. They may not have enough time to get that, get everything resolved. Let's say if it was approved or it's still pending, somehow it was, there was a motion to reopen and it was reopened, but it's just maybe fell into some sort of black hole. You may not be able to get that documentation in time. I don't know, that's kind of an unusual situation, so it's not the typical course, but if you haven't heard anything in 7 years, it may be that even an appeal doesn't take that long. So I'm not quite sure how your employer resolved if they did a motion to reopen or an appeal and where it went. But if the case number is not showing on the immigration system, you might be able to, again, use the Ombudsman service to at least see what happened to it, because it seems like no one knows what's going on. Yeah.
Okay, the next caller is Sandeep, number ending 2847, number ending 2847, Sandeep Kumar. Sandeep. Okay, let's take next caller. Bhaskar, number ending 6046. Bhaskar, number ending 6046.
Hey, thanks for taking the call. I have a follow-up question. One of you
can you just be a bit louder?
Sorry. So I have a follow-up question based on the previous caller. So, when my dependent uses her EAD, does it? I know it is. You've already explained that it will be a separate one, but will I be able to continue my H1 and later? Can she go back to H4 or she cannot because she just used EAD or advanced payroll?
Right. That's a great question. If if her EAD, if she's working on an EAD that isn't based on the H4 EAD, she's working solely on the one that has the basis under the adjustment of status, that does at that moment take her out of H4 status, because H4s aren't allowed to work unless they're on that H4 EAD or the EAD based on H4. So there's letters and numbers on EAD cards, and they each have their own like rules. It doesn't mean that she can never be an H4 again. Obviously, get into if like say she's working on the EAD, but she's no longer working, or it looks like maybe the filing, there might be some issues with status, and so we want to get back into non-immigrant status again. If you're still in H-1B status, all it takes for an H-4 to be an H-4 is someone on H-1B and a marriage or birth certificate, if we're talking about a child. It's a matter of going out of the country, getting the H-4 visa stamp, re-entering, and bam, she's an H-4 again. But if she's H-4 again and works on the EAD, then she kind of stops being an H-4. But again, it's a matter of, every time you make an entry in the United States on a visa stamp, you start anew. It's like a clean slate. And so if that's how some people kind of clean up status issues, let's say, you work beyond the date on your H-4 or H-1B. And so, you go out with the new H-1B, you get the stamp, you come back in, you're clean again. So the same happens with the H-4. So that's where, people are like worried that they have to, joking before, doing the belt and suspenders approach, having H-4 the whole time and having an EAD the whole time, when you really only need one or the other. And if you work on the EAD, but let's say you get an RFE from immigration, then they have, there's a red flag in your immigration history. If you have an H-1 or you can get an H-1B approved, then you get it approved, you go out of the country, you come back in, you answer the RFE. If all's good, all's good. If they end up, let's say, denying it, and I can tell you, in like 22 years of practice, this is 23 actually, I've only had like maybe 3 cases where there was something goofy with the status and they ended up denying the adjustment after a period of time. So it doesn't happen that often. You probably hear horror stories about that, but that's because you don't hear all the good cases. You hear about the crazy cases. But it's easy to kind of go back and forth into non-immigrant if you're going out of the country, getting the stamp and re-entering. So yeah, she can work on an EAD, and then if she needs to get back into H-4 status, she can do so as long as you're an H-1B.
Sounds good. We'll take the last caller. The number ending 2029, number ending 2029.
Hi, can you hear me?
Yes, please go ahead.
Yeah, my name is Raghu, and I'm on EB2. My priority date is June 15th, 2011. And I have a 20-year-old daughter. And if I downgrade and apply for 485, and if I get EAD, my daughter gets EAD. So will she age out after she turns 21, or she can use this EAD 485 and continue her status?
Right. So if you're filing the adjustment of status based on the filing date chart, so that second chart in the Visa Bulletin, it does not toll her time. So she's 20 now. So sometime in the next year, she'll hit 21. And there may have been some tolling before, based on when you filed I-140 and how long your perm was pending and all that. So there's a whole kind of equation that goes into that. So she may be, for immigration purposes, younger than 20 right now, but assume that, let's say she's 20 and she's going to age out. They may only approve her EAD until her 21st birthday, in which case Yeah, so is she on it? Well, I don't know if are you still on? Is
Yeah,
she
on.
on H4 or is she on F1?
She's still on H4.
Okay. Yeah, I mean, she's at university. I would see if she could get on F1, just because if she might age out in the next year, then this allows her to maintain her status. But again, that's the EAD. Technically, if they give her, let's say, whatever the period of time is, the normal 12-month, or maybe they might even do a 2-year EAD. There's been a question of whether or not they will go ahead and do 2 years. If they give her the full 2 years, and she has an adjustment of status pending, and she hits 21, and immigration doesn't come back to deny or revoke her EAD, she could still work on it. It's not, there are very, very few ways for an EAD to be automatically revoked. Typically, for most things, in the case of, let's say an EAD and the adjustment of status gets denied, that EAD technically is still good until that end date, unless immigration comes back with a notice of intent to revoke. And so she's just in a tricky, and you really kind of have to do the math to see when she's really going to age out if you're filing based on the filing date chart. If you're filing based on a final action chart, then her age tolls once you get that adjustment of status on file. And so that's why it's optimal. You said your date is in 2011?
Yes, I think June 2011, something like that.
Yeah, I don't think that final action chart for November is going to move to 2011, but you may want to hold off on filing your adjustment of status until the next Visa Bulletin comes out. If it comes out during the normal period, which is October, in this case, October 10 through the 15th, to see where the Visa Bulletin is going to go next month. If there's a sizable movement, then, maybe for the purposes of tolling your daughter's age, you might want to wait. I don't want to necessarily sway you one way or the other, but it's going to depend on how quickly you're going to be able to be benefited by the final action date as opposed to the final date. And it may be a matter of, and I'm not really sure the answers to this question, but if you file based on the filing date chart, but while your case is pending, your priority date is in that final action date chart, does that then start tolling the age? I just thought that question now. So that's something I'm going to have to research. And I'm glad you asked that question for that reason, because that might be the case, in which case there might be a benefit of at least filing this, even if it's a downgrade, because again, you might get that final action chart availability, especially if EB3, if you downgrade to EB3 and EB3 moves forward, the final action date moves forward quite a bit, then you might hit that final date chart with your 2011 date. So that's a great question. I'm glad you asked that. And if I figure out the answer to that question, I'll let you guys know.
Yeah, one last question. So let's say they have filed using the filing dates, and let's assume next month it became current. Will it protect the kid then?
Yeah, and that's what I was curious about, is that if you're filing based on the final action date, that protects the child. So if the date hits into the final action chart while the case is pending,
yes,
does that also protect the child? My thinking would be yes, right?
But do we have to notify USCIS? I don't know. They can keep track of everything.
I don't know. And that's the question that now I'm going to have to answer. And if anything, if it doesn't, then it's just a matter of withdrawing the other I-45 and refiling, right? So there's an additional fee and that's a hassle, but that's why it makes me think that you wouldn't have to do that because that seems silly,
Yeah.
right?
Yeah.
You're
but
only
at
protected
least-
if you file again, right?
Yeah, I believe, USCIS, doesn't keep a track of it. So at least we should write a letter and remind them.
Yeah.
Otherwise, it's, you never know. They come back later and say you're aged out.
Yeah. But
Yeah.
the CPSA rules and formula is, and I love math, but it gives me a headache.
Sure.
So.
Yeah, we'll keep an eye on your Twitter feed and, we'll try to get an answer for this.
Yeah. I'll post it there.
Yeah, another question,
Sure.
do EADs and EAD renewals, are they for an year or two? There are a lot of confusion.
Yeah. So because we've seen both, right? So lately they've been 1 year mainly, although for those that are stuck in retrogression for a while, those were 2 years, because we've had plenty where we're like, oh, great, 2 years. So it's an annoyance to have to file, but at least now we don't have to file there's no new fee involved because they did away with the fee increase and the rules beyond that. So, so we'll know when we start getting those approvals if they approve them for 2 years. It makes more sense to keep them for 2 years and advanced parole. It doesn't benefit them if they're not getting new fees. So might as well do less work by just making them for 2 years. It'd be nice if they were just like 3 or 4 years, but I would take 2. We'll settle at 2. Let's negotiate down to 2. But definitely 1 year. At 2, like I said, we've seen it both ways in our office over the last several years. So.
Okay. Fingers crossed. Okay. Before I conclude, I just want to, it's a tough situation to convince the employers for downgrades. So I've been asking a lot of attorneys if you can write some FAQs and, if you can write a blog where, employees can show their employers and persuade them to file in EB3. I know this is kind of a golden opportunity, and, you never know when dates become this close. I think the last time it happened was 13 years ago. So it would be really helpful if, if you or, your team can put up some FAQs and a blog, that we can share everywhere and reaches all employers.
It's not too much of an issue if they're not paying for it. So that's something to keep in mind, that it might be worth to cough up the $700 for the filing fee. And sometimes that's not possible, but, and again, just like we've said before, no asking, no getting, you can always approach it that way, or agree to sign a sponsorship agreement that you will stay for a certain amount of time if they pay. But really it's, I've not really seen an issue. I mean, obviously there's questions why, but if they don't have to pay, they're like, okay, well, we have to sign some things and maybe provide another financial statement. But again, every employer is going to be a little bit different, and small, they may just not understand it. But if you are needing to file an H-1B extension in the next year, knowing that, that's always a good, like, listen, you're not going to have to hire the attorney to file the H-1B extension. You are not going to have to pay the filing fee. If we can file for this now, and again, they may not pay for the fee, but to encourage them to at least support it by signing off on the I-140, signing off on the supplement J, and that way they avoid those fees on the H-1B. Because say, I'll have an EAD within 6 months. That way we don't have to worry about the H-1B. I know, again, some people like to have both, but if that is the tipping point with your employer saying, you don't have to worry about continuing to file for my H-1B and having it delayed and having to premium process it when it gets delayed, and because I can't get my driver's license unless it's approved, or what are those things are, there's a lot more flexibility in filing downgrade, so you have the adjustment of status and you have the EAD. So sometimes it's a matter of kind of advocating for yourself and saying, but showing them, again, money talks, showing them that it is going to ultimately be a cost savings, because, you know, the attorney's fees for the H-1B extension and the filing fees, even though if it's the second one, it's only $460, but still that amount versus, you know, the $700 filing fee or the attorney's fees for an I-140 downgrade are less than typically, I mean, at least in my office, they are, than the H-1B extension. So you can say, you know, this is going to be cheaper in the long run, and that provides you more flexibility and more stability. You're not going to have to worry about filing a stupid response to an RFE, even though you've been there for 12 years and they're still wondering whether an electrical engineer is an H-1B job. You know, I mean, we've all seen these off the wall RFEs that don't make any sense. And that's a hassle for employers. I mean, it's just an annoyance. And so there's a lot less annoyance in employing foreign nationals when they're on the EAD than when they're on the H-1B. So sometimes it's showing them the bright side, the benefit to them, not just to you. And it's showing that it's a win-win, then they might be more amenable to supporting it. You know, I just say, well, this is a way to get them further along. You supported the perm, you supported the first I-140 because you believe that this employee needs to have a green card. Let's continue on with it. Let's keep it going. So some attorneys are not that pushy because they're kind of afraid of their clients. But I don't think I'm that pushy either. But I just kind of lay it out there and kind of nudge them. But I also nudge back on the foreign nationals, saying, you know, your employer had a furlough earlier this year. They had to do a budget cut because of COVID. You know, maybe asking for them to pay the fees is not the greatest time right now, but asking them to support just signing off on the I-140,
True.
You know, given. So there has to be a little bit of give and take, and you know, good employers want to do what's right, but they also have other stakeholders and other considerations. And so if you can show where those can be minimized by supporting this, then I think you have a better chance, better luck with them.
That was a great idea. And, you know, it was a great session today with interesting topics, and thanks for all the calls and watching the show.
Guys, just one question. Hello, guys.
Yeah.
Chandan, 1421, could you please very quickly go ahead and ask your question? Chandan, are you there?
What's the number? Can you just let me know the number?
Chandan, number ending 1421. Hello? One.
I don't think anyone is on the queue. I think probably they have to press *6 and get on the queue.
All right.
Number ending
1421.
Okay, let me just unmute. Yeah, I think I unmuted. Number ending 1421.
Yeah, this is Chandan. Hello?
Yeah, please go ahead.
Okay, yeah. Thank you for taking my call. I know you guys had been for a long time. So this is my question, my priority date.
Please keep it very crisp, Chandan. Thank you.
Yeah. Okay, so my priority date is 2012 October. And this is a very unique situation that on Monday morning, there was an announcement that our company is being merged or acquired by another company. So under this situation, my present employer, the whole legal thing or the acquisition is going to be finished by December 2020. That's the announcement. So within these 3 months, is there a possibility that my current employer can go through the downgrade and the adjustment of status?
Yeah, so you're going to be, I mean, mergers and acquisitions happen all the time. Sorry, there's some. Ravi, can you mute?
Well, let me mute. Yeah, I did. Yeah.
Yeah, thanks. So that happens all the time. It seems like there's usually a transition period. So usually it's even if departments are reorganizing during the actual formal change doesn't happen until months later. But I don't know the actual timeline for your particular situation, but they could still file because your entity still exists. Same FEIN number still exists right now. That's where you want to go ahead and get on file to kind of take this opportunity, and then maybe sometime next month try to upgrade to premium processing, see if that will work, so you can get the I-140 approved. And then if there's a corporate restructuring after, that's where, I mean, if the job is really the same, the location, you know, everything is the same except for maybe the name of the employer and the FEIN number changes after the I-140 has been approved. I think it's still within the, you know, you can still do the supplement J and you can still do the portability after 6 months because, you know, the names change and structure changes, but if it's a full integration, that's allowed. I mean, there's lots of writings on mergers and acquisitions and corporate restructurings and how, you know, you don't necessarily have to start all over again. And so I would use this opportunity to kind of get in before everything is finalized, because, you know, your company October 15th, it's going to be the same as it is today. It's going to take a while. Sometimes I see them kind of delay and you know, it might be faster, but just the ones that I've seen sometimes take longer than they anticipate because there's more moving wheels. So.
Yep, sounds good. I think again, thanks, Tiffany. Thanks a lot for your time and helping the community by patiently answering the questions. I know it's been a long call for you. And again,
I appreciate the invitation. It's been really great to spend this time with you.
Yeah, I hope this this call was productive and we asked some tough questions. Yeah. And thanks again for the callers for watching the show. It was a great session with interesting topics. And, you know, we can't thank you enough, Tiffany.
No problem. Anytime.
Okay, bye-bye. Good night.
Good night, everyone.
Good night. Bye-bye.